people from, using the gun not intended for the purpose for which the gun was acquired. So, law requires. Thank you.
Thank you. The second question is, what is your view on the doctrine of separation of powers?
Separation of powers, it's somebody will say it's a political doctrine where the three arms of government are given their specific rules to play. And that's overlap. It's overlap in the sense that you can't say that because you are a judiciary, you will not have anything to do with the executive. And that the executive will also not have anything to do with the legislature. In fact, the core idea of separation of powers is to ensure that the three arms of government, there will be checks and balances. So no one arm will be controlling the others. So for example, it's the duty of you as honorable members of this house to ensure that when the executive is going astray from what it is required or they are required to do, you have the power to say that no, this one you are going ultra-vires your powers. The same with Parliament. If Parliament passes laws which are ultra-vires their powers, the judiciary should be able to tell the lawmakers that, look, here it didn't go well. You should have done this or you should have done that. So it's about ensuring that there are checks of balances so that there will be cohesion. After all, that is what good governance is all about. Thank you.
Please do.
Thank you. My Lord, in recent past, the last few years, you have some interference and overlapping where Parliament is making decision, is not yet concluded, and yet the judiciary jump on it to make decisions to stop it. Is that not usurping of or interference in the separation of powers?
Thank you, Chairman. The law, as I understand it, is that if what the Parliament sought to do has to do with interpretation of the Constitution, then the judiciary is seized with that jurisdiction to go into the matter. It's not as if the judiciary is becoming a schoolmaster. Of course, in any event, Parliament, you are masters of your own, what do you even say it? Masters of your own rules. So if the rules are fashioned in consonance with the law, and for that matter, the Constitution, I do not think the Supreme Court will jump onto your head and say that, don't do this, don't do that. So, I would say that that case in question that you are talking about, if it bordered on constitutionality and interpretation of some provisions of the Constitution, then the Supreme Court has a right to intervene. Thank you.
I wish you all. Thank you so much.
I'll then proceed to give the floor to Honorable Jerry Shaib.
Thank you very much, Honorable Chair. Honorable Chair, let me take this opportunity to welcome the Honorable nominee and Nana Doctor and all. I have a parcel of land in that area, so by extension, I'm a sub-chief.
Is that part of assets that you have declared?
Mr. Chair, I was given the land last night. Thank you very much. Nana Justice, congratulations and you are welcome.
Thank you, thank you.
Honorable nominee, you've been the registrar of the court, and I believe for a period before getting to the High Court and then the Court of Appeal. And therefore, you are versed with a lot of knowledge on judicial matters. Respectfully, would you recommend any judicial reforms to this committee?
Certainly, thank you. I've already made mention of some reforms that we can put in place to ensure that cases that come before us are tried expeditiously. And I made a point of this e-justice system. I think the rules of court that we also work with needs looking at again. For example, the High Court rules, CI 47. Indeed, we had the previous one, which was promulgated in the 50s. It was only in 2004 that we changed it, and that has become our tool that we work with. Now, there are also inherent difficulties or problems with some rules of our engagement. For example, interlocutory appeals. I'm talking about interlocutory appeals, both in civil and in criminal. Interlocutory appeals, when a decision is made by a trial judge, while the case is pending, most often the party that is dissatisfied will want to go on appeal. In that case, and if he applies for stay of proceedings, it's certify the hearing of the case. So I want to suggest that, yes, they have the right to appeal, but there must time limits within which the appeal must be heard so that it doesn't affect the hearing of the case adversely. Now, coming to the criminal aspect of it, now it has become fashionable that if you are doing the case as a judge, when you cough, a party want to go up. When you sneeze, and sometimes they go even as far as to the Supreme Court. Meanwhile, then the case will still be pending. So I strongly advocate that the right of parties filing interlocutory appeals in criminal cases where the prosecution has not even ended its case must be stopped. And we can only do that through the amendment of the law, that is Act, talking specifically about Act 30. Now, another area which also needs reforms is our jury system. We inherited this system from our colonial masters, Britain, where they started this system. As I speak, India, some Commonwealth countries like India, Singapore, and South Africa, they have abolished the system. Why? Because it's not functional. Now, our experience in our jurisdiction has shown that that system has outlived its usefulness. So I would advocate that instead of the jury system, there must be assessors. Now, if you permit me, I will give one example. When I was in the High Court, I did assizes. That was before my transfer to Sekene in 2015. I did a case where I had summed up the evidence to the jury, and as much as possible, I did it that everybody in the courtroom or or maybe those in the courtroom who understood what we were saying, anticipated that the jurors were going to, bring a verdict of guilty. They came out and said that the accused persons were not guilty. And you see, the law is also that they are the judges of fact. So their verdict is even binding on you, the judge. You may disagree, but you cannot open your mouth. You have to work with it. And there was a doctor who has been subpoenaed, have come from Ankafor Psychiatric Hospital to give evidence in the case. The doctor was in the court when I was delivering my seminar. The man was so disappointed that he said that if that is what the jurors here are doing, that I will never come back again. He didn't come. So the case will have to be, I left it because I was then on transfer to Sekedi. So we can give examples, but because of constraints of time, I will not do that. But I'm saying that in its place, we should establish what we call assessors. In assessors, the judges who will try the case will be 3, and there will be lawyers. I mean, there will be lawyers who have become judges. They will sit on the case. And we have it on our statute books when judges try treason and high treason offenses. It's assessors. We don't do it jury. Our jury system here is porous. Some of them have become professional jurors. So that is one area which our advocate. Thank you.
Thank you very much. My Lord, I asked this question yesterday. I think it was Sir Dennis, my Lord Sir Dennis, that responded. But just opposing that with his response and yours, I'm looking at the issue of, for instance, the criminal interlocutory appeal, that maybe a suspect or a witness believes that whatever ruling you made or whatever consideration you made would affect him or her. And if it is not corrected at the point that it has to be corrected, you would end up giving a judgment that would convict him and others. You don't think that the issue of time is key? That's what you said. But are you in the position to propose the time frame within which such appeals should be considered? Which I think is very, very crucial. Because if, for instance, I'm able to know that I can get an appeal for an interlocutory matter so that the court can proceed to deal with a substantive matter, would you consider giving us an idea of what time that appeal should be considered?
In my earlier submissions, I did make a point that if a party is aggrieved with a decision by a court, because the case has not traveled to its end and it is still ongoing, then that will be an interrogatory decision that by the court. Now, it's tried that when a case has not come to an end, or when in criminal matters, when the prosecution has not closed its case, the judge has no power to convict. Therefore, if you want to appeal against an interrogatory decision, you will not be, as it were, at that stage, the court cannot convict you and sentence you. So earlier on, I did propose that right for parties, it could be the prosecution or it could be the defense, to file interrogatory appeals while the case is pending, must be reserved to the end of the case or at the end of the course of the prosecution's case. That one is allowable. I think that so that the hearing of the substantive matter doesn't suffer. Now, if it comes to the time that we should allocate for filing of the appeal and hearing it, I will propose that when the appeal is filed, interrogatory appeal is filed, the registrar should be able to compile the appeal within within 14 days. Because invariably, it's not every document that has been tendered in the proceedings that will have to be embodied in the record of appeal. It's only if it's an application, yes. It will take the processes that were filed in connection with that application, and then the decision of the court itself, that will be the relevant records that must be sent to the Court of Appeal. And when it is sent to the Court of Appeal, then the rules of court must also amend the rules to say that if it's an interlocutory appeal and it's of urgency, it's urgent, then that appeal must be heard within at most, is it at least or at most 30 days, so that it will not badly affect the hearing of the substantive case at the trial court. So that is my proposal.
Very well, thank you very much, my lord. My lord, were you once a magistrate, and would you pray that career magistracy be abolished?
Not at all. I would rather advocate that the system must be, must be strengthened, for want of better word. Because you see, this career magistrate came about as a result of when the Courts Act was amended. First we were sitting as tribunals with, panel members. I think in 2001 or so, when President Kufuor came into office, the Parliament sought to reverse the system back to its former. So now, then we had magistrate. Because of the vacuum that was created, most of there were so many vacancies. So that was why at that time it became necessary for the then Chief Justice to fashion out this career magistrate system. And it is not, Ghana is not the only place that we have, applied this system. When you go to Nigeria and Zimbabwe, they have that system. And there's a career part where you can start as a career magistrate, and you, by dint of hard work, integrity, and your competence, you can rise to become chief magistrate, which is an honorous grace of a high court judge. Now, here, there's some difficulty with our system. Currently, because the service felt that we must encourage lawyers to come to occupy those positions. And as I said earlier on, the lawyers, when they want to join the service, want to start from the superior courts. So, as at now, there are about 70 plus more career magistrates still in the system, and those ones are in the hinterlands, and they do the same work as that of professional lawyers who have become magistrates. So instead of scrapping it, it should be strengthened. They must be given the opportunity to also go to the law school, educate themselves, because when they come back, they also come and join the service. There is a second judge in Kumasi, started as a career magistrate. He had the opportunity to go to school, and now he's a second judge. So instead of scrapping it, because if you scrap it, and there are vacancies in the hinterlands, as Madam was saying, who will go there to, do this career magistrates who have been going push to the hinterlands to handle the courts there. And it's important that we should, encourage them to also come up with their competence. Thank you.
Well, that would be, I have my final question. And sitting in as a judge, Lord, what would be your role in curbing the menace of Galamsey? What suggestions would you put forth? And how are you going to deal with issues that come before you, especially on Galamsey?
First and foremost, we have this minerals and mining laws. And the offenses that the law creates are deterrent enough to punish people who are involved in Galamsey. What is left is the implementation, the effective implementation of the law. So I think there should be a collaboration between the service and then the police or the enforcing authorities. After all, we are fighting a common cause. If we allow this to go on, and in the next 5 or 10 years, we are importing water because all our water bodies are destroyed. Can we bear it? One area I also want to maybe hammer or suggest is that there are foreigners who also engage in this Galamsey activities, destroying our forests and the rest of it. You know, when they are arrested, especially these Chinese people, when they are arrested and sent to the court, the difficulty is that they don't speak English. Even if they can, you know, they understand English, they will refuse to speak English. And because the judges or the police enforcement agencies also are unable to speak their language, it becomes more and more difficult to get them prosecuted. So I will suggest strongly, or I recommend, that the judges who are in the areas where these Galamseys are going on, the judges must either be taken to China for further studies in Chinese language, or they should fashion, the JTI must be resourced to bring experts to come and train our judges. That will also is another way of, because if the person has committed offense and he can't speak, you can't prosecute him. Then it's as well saying that, oh, let me leave him for him to go away. So that is the recommendation I will make. Thank you.
But my lord, why not get interpreters?
Oh, that is also good. It's another point. But you see, the interpreters themselves, sometimes they are also a problem. So if the judge himself understands the language, Chan language, it will be better served for them to understand what he is doing, what she or he is doing, and for us to, you know, be able to curb the menace of Galamsey. Thank you.
Thank you, my lord. So, how does it mean that you want to deport a Chinese person involved in Galamsey? What would be your stand?
This is a difficult question. Difficult in the sense that the power to deport is the executives. I'm not in the executive. So I cannot, with all due respect, answer this question. Because the discretion is the executives. Thank you.
Thank you very much, my lord. I wish you all the best. Thank you. Thank you, Chair.
Yes, Honorable Koku Ruketegan. You have the floor.
Yeah. Thank you very much, Mr. Chairman. Nominee, my lord.
Yes, sir.
Justice Philip Bright Mensah.
You are right, sir.
From Amosman.
Yes.
My neighbor. Your neighbor from Cape Coast.
Uncle, I know.
Aiko.
Yeah.
Going through your CV, just like Abazi, going through your CV as many of us have done here, your CV is an epitome of what will be described as you have gone through the mill.
Thank you.
You have pretty much climbed the stairs through our courts. So obviously from where you will be sitting, God willing, you will have a much comprehensive view of the whole court system. And I have no doubt in my mind that you will do a good job
Thank
for
you.
Ghana.
Thank you.
My questions this morning is on how we can improve the inefficiencies within the court system. In Ghana, even though we have district courts, which are supposed to deal expeditiously with matters, but we often hear that the courts are becoming like the circuit and high courts, I'm told.
Circuit and the High Court.
Yes,
The district court.
the district courts.
I see.
And we're talking about inefficiencies here.
Okay.
Do you think we need small claims courts which can deal with matters involving claims that are, say, less than 10,000 Ghana cedis, and deal with those cases in a day or a week maximum? Thank you.
Thank you, Mr. Chair. Indeed, the service itself has, over time, devised some means or strategies by which such cases. So, with all due respect, you are not the only one who has raised this question. In fact, even in Accra, there used to be small claim courts. The rationale is that somebody who has a small claim must be able to walk to the district court, Graboso, where I also did my work there, so that you will not require the services of a lawyer. You can walk in there, and of course, the district court is a case, the court of summary trial, so you don't have to file too many papers. You go there, if it's about money, as you are saying, the defendant will be served, and when they appear before the court, the magistrate will ask him, look, you owe this man, are you liable or not? If he admits that he's liable, then you enter judgment there and then. So it's a very good suggestion, a good idea, but it will also depend upon our lawmakers here. If you give us money to be able to set up the courts, we will be able to set up this small claim court that you are talking about. Thank you.
Mr. Chai, thank you very much. Again, my Lord, I'll go to my second question, no follow-up question,
Okay.
but also relates to the same inefficiencies within our courts and how we can improve on that. And this time with technology.
Okay.
You did say earlier on that if we have, electronic systems within a court, we can improve on things. I think the problem goes beyond just the electronics, but
Okay.
the whole data management of the courts. The data collection and the management of it. You realize that maybe the systems are not there, but I think it would be a good idea for the court to start getting people with expertise in technology to help, sort of augment the work that you do. And that the court should be looking at management systems, because the issue is to do with management. The reason why things are quite slow with the courts. So would you think that it would be a good idea to invest? I know you've done a lot of, you started many years ago to do some automation in the courts. Do you think you still need more investment in automating the court? To an extent, it cannot be 100%, but at least to a level that will make processes much faster than having some years, some cases sitting in court for years without any solution. Thank you.
Thank you. Certainly, yes. The government or the executive, for that matter, must make conscious effort to invest in this project. I said that in Kenya and in Tanzania, I'm told that when you want to electronically file your cases, you walk into what we call here communication center to do it. So if we have been able to also invest in the system such that it's across the board, across the length and breadth of the country, and we educate people as to how we should use the system, it will help us a great deal, because it will mean that most cases will be tried as expeditiously as possible. And when we are able to do that, I think the confidence and trust in the judicial system will soar up. So I will still plead that when our budget comes, please try to even top it up for us, so that we use part of the money to invest in this kind of, system to improve on our efficiencies. Thank you.
Follow up, Mr. Chairman. Would it be an encouragement as well if this investment comes in the system for judges and the whole judicial system to equip themselves with modern technology to be able to, again, be up to speed, in addition to perhaps introducing Chinese classes so you can deal with Chinese issues? Thank you. Since they become quite rampant in our system now.
Mr. Chairman, I do agree. I don't have any qualms about it at all. We should improve our system. Everybody, I'm sure this time, most of the judges, if not all of them, they know how to, use their laptop. So it's a very laudable idea, and I thank you for the suggestion.
With this, I just noticed on your CV that you're actually a chief of Amasman and the Nyimfahene of Asebu traditional area. Would you let us know what your stool name or title is, please?
Mr. Chairman, I'm Nanamwa the 8th, or let me say it in French. Nanamwa Otoro our tree. May I must my him, and now may I invite him or Asebu traditional area. Mama here not. Okay, the chief of Asamanfi, the 7th, he has come all the way from Asebu to come and support me. And the Queen Mother and the other chiefs, they are all here to give me their moral support. Thank you.
Justice, Bojo, Bowuzin Bill, one he's in the bill.
Nana more auto do our tree.
Nana more to our tree.
And you.
Please put your hand. Nana, Utinkwa. Mr. Chairman.
My Lord, ni hao. Ni hao ma.
Chinese, hey, this is the first time I'm hearing it. Thank you, Chair.
It's greetings.
Oh, okay.
Yes.
And the meaning is what?
Like, how are you?
Oh, I'm fine.
I'm fine. Ni hao ma.
Me how ma?
Yes.
Hey, I see. Thank you.
Yes.
So
Honourable members, I will proceed to give the floor to Honorable Patricia Piaget.
Right, thank you very much, my Lord. Congratulations.
Thank you.
It's nobody but Mama Pat from Kumasi. Yes. We'll be listening to you. Very interesting journey towards the judiciary. And one of the things I would like to ask is for you to share with us your personal or professional obstacles you faced on your journey to becoming a justice of the court. And how your story might inspire the next generation of legal minds. Thank you.
Thank you. If I understood your question, you were asking how I was to become a judge or
Yes, and share a story that will inspire the next generation.
Yes. I think first and foremost, if you want to become a judge, you need to make sure that you should be prepared to work hard. That is point number one. You're also talking about your competence and integrity. The work of a judge, you are settling disputes between feuding parties. So as the statement always go, you must not only deliver justice, but you must also be seen to do justice. My journey, I told you I've had a checkered history, but I want to give one example. You know, it is resilience. You must persist. In fact, when I read the diploma in public administration, and I had the opportunity to go to school again to read law. I had then been bonded over to serve the judicial service for 4 years. When I went back to Sekeni, the following year I had the opportunity to go to the university. There were all kinds of obstacles, but it took the intervention of a very good man, the late Justice Archer. He was then the Chief Justice, and I'm always grateful to him that he eventually permitted me to go to school, because I was a family man and I could not have gone to school without steady leave with pay. So I worked hard, and my philosophy in life has always been that something worth doing must be done well. In fact, permit me to emphasize that I started my career as a magistrate in Sefiu also. I didn't say that because that place is far from Accra, I will do my work as I choose and as I please to. No! Rather, I worked extremely hard, and I had the opportunity to even teach myself the law, because I was always studying the law. I was always reading my law reports. I was already reading my books. And I say this without any shadow of contradiction or whatever, that it was as a review also that the late Chief Justice Aqua identified me because of my hard work. So what I will say is that every magistrate, judge, whatever, you must work hard. Let your work speak for you, and let the promotion be on merit and not of any other consideration. Thank you.
Thank you very much for sharing this with us. My Lord, I want to tease your view on this issue. You know, in Ghana, Ghana mandates retirement at 70. We have other jurisdictions that looks, especially even in America, that provides life tenure. Would you recommend extending Ghana's retirement age to 75? And whether that will require a constitutional amendment? And if you personally will support that change? Thank you.
Thank you, Chair. I will never advocate that the age of a judge, Supreme Court judge for that matter, be raised from 70 to 75. Why? In the other jurisdictions that they retire the workers of life for life, so they will maybe run to the age of about 80 plus. They, as you have all become aware, the cases that will go to the Supreme Court, they are few. In our jurisdiction, in our part of our jurisdiction, the Supreme Court is always dated with so many cases. And, Madam, unless you want to be a lazy judge, you will find out. If you want to do the work and do it efficiently, you need to work very hard. And it is very stressful. So it's not advisable that when you get your retirement age of 70, then you say, I want to go to 75. If you don't take care, the 75 will not even reach, and you will go and join your ancestors. So let the law remain as it is, 70, and then you will bow out from the bench. Thank you.
My Lord, what is your view on the Article 66? The 2-term for a constitutional term of 2 for each of. Read Article 66.
Okay, thank you, Chair. 66(1) says that a person elected as president shall, subject to clause 3 of this article, hold office for a term of 4 years, beginning from the date on which he is sworn in as president. Now, clause 3 of that provision says that the office of the president shall become vacant, A, on the expiration of the period specified in clause 1 of this article, or B, if the incumbent dies or resigns from office or ceases to hold office under Article 69 of this Constitution. My view is that there's no ambiguity as to the terms that a president, an elected president, must, hold. So I will go by this law. I do not think I have anything to say in contravention of this, or I will not prefer any amendment.
We take it that you don't have any issue and you feel that 2-term is 2-term and it cannot be reviewed under any circumstance.
I think my position is clear, that the law is clear, so we should maintain it as it is. Thank you.
Thank you very much. My other issue, going by your answer to my second question, that you don't think that we should review the mandate for retirement. From your CV, I see a challenge because I'm really going through your calendar. And if I go through your calendar, I see one thing, that your effectiveness will be just for about 3 months. And yes, if going through the calendar, you go to holidays, vacations, and all that. So I am thinking that if we don't review that law, how can you be, because you are an institution, and therefore, if you have to, Ghana has to benefit your very existence in the judiciary. It is important that we look at that law again. Thank you.
Thank you, Madam. Thank you, Chair. My position on the review of the age hasn't changed. I will stand still by it. Now, the challenge you are talking about, Mr. Chairman, there are precedents in the service. Some judges were appointed, and if you permit me, I will mention names. Justice Professor Kuji was appointed to the Supreme Court in August 2003 during the time of President Kufuor, and he retired in April 2004, a period of about 8 months. Justice Afrewu was also nominated from the Court of Appeal to the Supreme Court, also during the time of President Kufuor. He was there for only 1 year. So the president is there. I also think that promotions come from above. So, as a Christian, and if it has pleased the Lord for me to be promoted, even if it is 1 day, I think when I go there, I will do what is expected of me, and I will leave the service honorably. Thank you, Mr. Chair.
Thank you very much. Nanamwa, Utsirwa.
Mr. Dasi.
Honorable member is now the turn of the ranking member of the committee, Honorable Alexander Fanyumaki.
Chairman, thank you very much. Honorable nominee,
Yes.
questions that I shall take you through. We'll look at areas such as perceived absence and reluctance of Ghanaian courts, particularly the Supreme Court, to engage in bold, transformative adjudication in matters of public interest, social justice, and constitutional enforcement. In fact, I have drafted these questions to test your judicial philosophy, your understanding of constitutional interpretation, and your views on the proper role of the judiciary in nation building. I wish you well as we proceed.
Thank you.
By the way, I heard you talk about your journey thus far in public life. Just in a very short phrase, say something about what you've learned, especially in very difficult moments, to inspire the youth of Ghana, who perhaps by unfortunate situation of their background are placed at the lowest ebb of fortune's wheel and feel that there's no life for them at all.
Thank you, Mr. Chair. What I would say in response is that hard work pays. So the youth must be conscious of the fact that in shaping their lives, hard work must be at the center of whatever they have chosen to do, whether career, job, and what have you. And as a person, you must also fashion for yourself. You must plan. You must plan for yourself. My journey started as a recorder. If I have not planned that, I also want to be like, and in fact, I was inspired by both the judges and the lawyers that were.
Enough, my lord. Enough, my lord.
Thank you.
Lord, your records have it that you are a chief, correct?
Certainly, yes.
You are a gazetted chief.
I am.
Since when?
2016.
Where you come from, did you ascend to that throne through maternal inheritance, or it was an honor, or through paternal inheritance?
Maternal.
Maternal, very well. So you've at all times been a royal, correct?
Certainly, yes.
Very well. Do you see the performance of your traditional role conflicting with your judicial function?
Thank you for the question. In fact, both the traditional role and my role in the service are very important and dear to my heart. So I've tried to manage as far as possible to ensure that I give equal attention to the two. Of course.
My lord, it's enough. What I would suggest strongly to you is to have at the back of your mind the rule of brevity. I don't want to keep you for too long, but if you decide to be answering my questions with long answers, then you may stay for long and the impression will be created that the leader of the mighty minority is keeping you for too long. So just bear that in mind. Now, in your career as a judge, have you had the occasion of spotting talent at the bar and taking interest in directly inspiring such talent, including nurturing them to rise in the profession?
Thank you for the question. Indeed, the questioner himself was practicing in my court. I had then come from Kumasi, and he has also come out from the law school. Look, the point or the habit I have cultivated over time is that I always want to encourage young practitioners to have confidence in themselves. It's not good that as a judge, if a lawyer came before you, and a junior lawyer for that matter, I mean, we are all prone to mistakes. If a junior defaults, then you'll be shouting on the person. It has put some potential but brilliant lawyers shy away from practice. So I try to, from Kwasi right down to Accra here, and even in second aid, you can check. And you are testimony of that. Thank you.
My Lord, now let's look at the role of judicial activism in a constitutional democracy. What is your own understanding of the role of judicial activism within Ghana's constitutional framework? And to what extent should judges be willing to creatively interpret the Constitution to address emerging injustices or legislative gaps? The emphasis here is creatively interpret. In fact, I'm not singling out a particular judge for mention, but I've been reading his judgments lately. If you look at my Lord Kulendi's ruling, you can see a certain path. Okay? And you realize that he is pursuing certain path, perhaps because of his long years in private practice, and from private life to public life, he has a combination of these and is shaping his approach in the law. I have seen your judgments, and I, to some extent, can say that your thinking in the law is towards that pragmatic approach to seeing things. However, quite broadly, I mean, for over 10 years, I have not practiced in your courts, and I have not had the benefit of reading your judgment lately. So I want to know from you, how willing are you to creatively interpret the law? We are aware recently that there's a bold decision that when a process is filed and it is served, although it may be praying for that process, may be praying for an injunction, until that is expressly granted, there cannot be that presumption that you should be stopped. That's bold and very creative. What is your own position?
My Lord, before you come into answer, few minutes ago you've been asked to observe the rules of brevity. I would want to plead with Osahin Togbi to also observe the same rule in asking the questions. Please, you have the floor.
Thank you so much. Mr. Chair, yes, they say I should be brief as much as possible, but some questions too will allow you to go into a little details. Now, the case in contention...
I'm not limiting you.
Okay.
So please proceed. I mean, this is a critical matter that you should...
I do not think that case espoused a general rule that if an injunction application is filed, will not stop a party from doing whatever he is doing. My appreciation of that case and the ratio in that case was that if it's as a man constitutionally mandated body, then, of course, the law has been that the court can sparingly grant injunction against a constitutionally mandated body. So I believe it was on that basis that this thinking has come. I mean, and the law, is said that it's always evolving. So if the position formally was that you can't grant injunction in any case against a constitution mandated, now they are saying that even if the application is pending, you cannot stop the. That is the position of the law currently, and until the Supreme Court gets the opportunity to depart from that position,
But that was by way of example. So my question to you that how willing are you to be creative in your interpretation of the Constitution to address emerging injustices or legislative gaps? I mean, I want to know from you how willing you are to be creative in your interpretation of the law. As to the debate regarding your understanding of the ruling, we can use another forum to discuss that.
You see, Tufo and Attorney Nyana has settled the law that our constitution is an organism capable of growth. In fact, in other jurisdictions like Australia, Canada, and the rest, in Australia they say that even the constitution is like a tree. It has to grow. Our constitution is the fundamental law of the land. And it's, apart from being a legal document, it's also a political testament capable of growth. So when the situation arises that we have to interpret the Constitution, the provisions of the Constitution, to meet the exigencies of the time, I'm all for it. I mean, what is the sense of a judge, especially when we are going to the Supreme Court? And no, I'm not a timorous soul. I'm not timorous. I will apply the law as I understand it and interpret the Constitution to suit the exigency of the time. So that is my view on that.
Thank you very much.
My Lord, so let me get this from you. What is your own understanding or your appreciation of judicial activism as a judge?
There's this, they say that judges do not make laws. Of course, that is the general rule. But it's also tried that where there are gaps, it's permissible that the judiciary will grease those gaps to make the law understandable, for everybody to, follow it. Let me give a typical example. If you look at, I think, Article 22, it is provided that Parliament should pass law on property settlement when the Constitution comes into force within 6 months. Parliament has not done that, but it became necessary for a Supreme Court judge to espouse this principle of jurisprudence of in this case of Mensah versus Mensah. You see, you will call it as judicial legislation, but it was necessary because I do not know the Parliament has then not passed the law, and the situation demanded that there should be something about about the case. And that's why jurisprudence of equality principle came in. And it was a judge who, being bold. So if the situation calls for it, and I feel that it is Parliament who must do it and they haven't done it, or the law is such, is so ambiguous that we need to oil it, put greases in it to make it understandable, readable. Why not? I'll be prepared to do it. Thank you.
Now, my Lord, let's delve a bit into Article 132, the supervisory mandates of our court, of the Supreme Court. 132, yes, please. That deals with quo warranto, mandamus, certiorari, etc., prohibition and all. Now, my practice at the Supreme Court, I came across some inconsistencies in terms of the approach to this constitutional provision. And in fact, as a practitioner, anytime I had my case before the Supreme Court, certiorari application, and I saw a particular panel, I could straight away predict that this panel, they would not hear me. And at all times, I was never wrong. Because you could see that if this particular panel is presiding, however meritorious it is, they will say, go on appeal. Why are you coming here? And in fact, the anti-Article 132 bench would always say that supervisory powers in 132 are discretionary. So they would not venture, however meritorious your case may be, because they want you to go through the appeal process because you have appeal as of right. And they will further argue that go through the mill. Whereas you also believe that invoking their supervisory rights would lead to justice for the party who is aggrieved. What is your own view about Article 132? Do you hold the position that even where the error on the face of the record are so patent, you must discourage certiorari applications or prohibitions under 132 by telling lawyers or parties to go through the long haul?
Yes, my Lord, you may answer the question subject to the fact that some Supreme Court judges are anti-Article 132. So you may proceed to answer the question.
My Lord, hold on a second. Chairman, with the greatest respect, I don't want us to repeat what happened yesterday. If you have a certain appreciation of my question, you can take it with me privately. But this interjection as if subject to what I meant. If you go to court, I don't know about your practice at the Supreme Court, but I am an active Supreme Court practitioner, and all the judges know. If you go to the court, you know this is a pro-state bench. This is a pro-this. We know. We are, those of us who are very active, we know how they think. If the matter is on a certain direction, how they think. There are some law judges that when you go with a certiorari application, they will encourage you to go on appeal. So don't come in by saying that subject to anti, it is not derogatory. What I meant by bringing that one in was not to denigrate anybody. So please, let it flow. Then we can make progress.
Well, I do not want our record to show that some Supreme Court judges are classified to be anti-Order 32.
It
So
is
please
not. Maybe you
proceed
don't
to
understand
answer
it.
the
It is
question.
not. It is not derogatory.
Please proceed to answer the question, man. Was that?
Oh, thank you, Mr. Chairman. Mr. Chairman, are you listening?
Please proceed to answer the question, minus that.
They were calm. If you want to discharge, I'll stop. You should discharge him, let him go and have his way. History will record. And one day, they would also be in opposition and this thing will play to them. What is this?
Please, you have the floor. Proceed to answer the question, minus that.
Thank you, Mr. Chairman. I do not know those judges the chairman is talking about, that they are anti-Article 132. But you see, I think the practitioners should also be circumspect, because it appears to me that it has become fashionable that cases that are tried in the High Court or in the Court of Appeal, the least opportunity, the lawyers will want to go to the Supreme Court by way of certiorari and, the prerogative applications, because they feel that that is shorter than going through the appeal process. But Mr. Chairman, see, there's this principle that the Superior Court, there's no case is above that of. So it has always been cautiously maintained that before you touch the decision of a Superior Court, by judicial review, you need to be cautious. So the best option, to me, I think that is what the anti-132 provision chairman is talking about, because they will take the position that once a Superior Court is a court of unlimited jurisdiction, they have, it's presumed that the judges on that bench are presumed to know their law. Of course, as human beings, they are also prone to make mistakes. But if the matter is for an appeal, I think it will be better served if you go to appeal. Because when you go on appeal, you see, the Supreme Court, they will have the opportunity to write judgment based on the merits of the case. One is about certiorari. Certiorari, we are not talking about the merits of the case, but about procedural rules. For example, if it is established that the error was patent on the record that said that it was utter varies the powers of the court, that one is acceptable. Or if they didn't have the power at all. But if they had the power and they did the mistake in the exercise of that jurisdiction, the best option or the better option is to appeal. So my position is that 132, yes, but
Hello, would you be the type who would hasten slowly in dealing with matters of certiorari, or you look at it case by case?
I will look at it on a case by case basis.
Very well. Let's make progress. Now, let me take you through constitutional mandates and judicial restraints. Our country's constitution grants broad interpretative authority to the judiciary under Article 2 and Article 130. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways?
Can you repeat the question again?
So, I'm saying that Article 2 and 130.
Yes.
In your view, these provisions clothe you with those interpretative powers. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways? Now, I would give you one case.
Okay.
The Pani Lamte versus the Kojoga Adra versus Attorney General matter. My Lord Acting CJ wrote the judgment for the panel, and I will just explain to you. This had to do with public servant participating in our partisan political activities, and the contention of the plaintiff was to the effect that yes, the 93-1, hold on a second. Because students are listening to us, I don't want to make a mistake. 91 to be, yes, it's here. 94, 3B, those prohibitions. Now, the contention of Mr. Agra in that matter, which had to do with the eligibility and the prohibition, who qualifies to be a member of parliament. So his case was anchored on 94 3B, which says that, let me read it in full. A person shall not be eligible to be a member of parliament if A, is prohibited from standing election by law in force in Ghana by reason of his holding or acting in office, the functions of which involve responsibility for or are connected with the conduct of an election, or responsibility for the compilation or revision of an electoral register. B, is a member of the police service, the prison service, the armed forces, judicial service, the legal service, the civil service, the audit service, parliamentary service, the statistical service, the fire service, customs, excise and preventive service, the immigration service, or the internal revenue service, or is a chief. Now, in this matter, Mr. Kojoga Adra's contention was to the effect that yes, these have been listed, but there were officers in the public service, specifically Ghana Highway Authority and Ghana Education Service. And he does not understand why, if somebody is a member, a staff of Ministry of Education, the person is prohibited. Ministry of Health, the person is prohibited. Ministry of Roads and Highways, the person is prohibited. But if the person is a staff of Ghana Highway Authority, the person will say that I have not been listed. Now, my Lord Bafuboni took that conservative stand to say that to the extent that those others have not been listed here, it means that the Constitution did not contemplate them to be part. I haven't seen anybody back to really further tease the mind of the Supreme Court on this. So it still remains a law, and subsequently those who are in the public service mainstream but not listed here are part of our partisan political activities. So my question to you with this background is, to what extent would you say that the cautious approach in exercising this power has affected governance in one way or the other? Because obviously I see some practical challenges here where a minister is instructing an officer as Ghana Highway Authority or GES and knows that the person is the constituency or regional chairman of a party and is in opposition. I feel that the court was too reluctant in dealing with this matter. What is your view on that?
My view is very simple. Once the court has spoken, that is the law. Yes. So I do not have any useful, addition to it.
My Lord, with respect, I'm not asking you to critique. What I'm saying is the basis or the gravamen of my question is the cautious approach. What is your view on this cautious approach to interpretation regarding governance? That's all. I only gave you that example to give a background because you said you didn't understand my question. You get my point now? Very well. Then
Honorable member, my Lord has answered the question that once the court has made pronouncement on the matter, he has no view on it. I think his answer is very clear.
I drew his attention to the fact that I wasn't asking him to critique the decision of the court in the Kojoga Adra case. I only introduced it to draw his attention to the mainstay of my question, because he had come back to say he didn't understand the import of my question. So I needed to give him that background. So I am not asking him to question the judgment of my Lord Bafuboni, who spoke for the bench. Please. Now I have clarified that what is your view on the cautious approach by the judiciary in exercises its power of interpretation on governance? That is my question.
Very well, my Lord.
Thank you, Mr. Chair. I do not think that judiciary in every case has been cautious in interpreting the Constitution to shape our governance or our democracy. Indeed, there are cases which the Supreme Court has determined that has even helped shape our good governance and democracy. And a typical case, example I can give is G.H. Mensah versus the Attorney General. In G.H. Mensah, the summary of the case was that, or let me say, it's bordered on interpretation as to whether the ministers which the then president wanted to retain them in his government during the second time to be, to carry on with their work without parliamentary approval, because President Warren has won the second term and he has taken retained some of the ministers. Now, there's this, the Minister of Finance at the time, I think Kwame Poposo, had prepared a budget which he was to present to Parliament. And the issue rose up as to whether he has that power to appear before the Parliament to present the budget. There was debate here and there, and the then majority said that we are going along with it. And James Mensah said, no, let's go to Supreme Court for interpretation. They came to Supreme Court, and the Supreme Court held that the term or the tenure of those ministers ended with the term of the president, so that if the President Warren has not won the elections, it will mean that they would have gone away. So they have been ushered into a new, they said fourth what? First session and blah, 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 blah. So I think that was the second session.
You mean the second parliament?
Yes.
Rawlings 193.
Yes.
And then 196.
Yeah.
So that was the second, my Lord, just a moment, because of the little ones who are listening. So the second parliament of the Fourth Republic, you mean?
Good.
Very well.
So the Supreme Court that once their term of office or tenure of office ended with the first regime, then they cannot be maintained or retained as ministers. What lesson do we learn here? The Supreme Court held that the purported retention of those ministers violated Article 87 of the Constitution. So it prevented the occurrence of, recurrence violations of the Constitution, the provisions of the Constitution. So depending upon each case, and as you rightly said, it should be on case-to-case basis. So Supreme Court, they are pragmatic. After all, they are policy court. They give directions to shape our good governance, rule of law, and the rest of it. So if they have been cautious, and they have the right to be cautious, if it demands that they must be pragmatic, they have to do it. So that is my answer to your question. Thank you.
Very well, my lord. My lord, you've spent the better part of your adult life after your call to the bar on the bench. I once remember you in your court saying that though you, the judges, don't go out, but perhaps you are the first to hear of every public rumor or gossip. I remember you telling us in your court. What it means is that you are equally aware of criticisms that emanate from the public space when you speak to shape governance and public opinion. Lord, would you agree with the position by some critics that the Supreme Court of our country has had the occasion to miss opportunities to provide judicial leadership in advancing constitutional justice and or protecting fundamental rights?
The Supreme Court has neglected its duty in shaping the... Is that what you said?
Oh, my lord.
Can you repeat
Very
that,
well,
please?
very well. So, you hear of criticisms, definitely, even amongst you, yourselves. Your judgment could go up and your brothers above you will say no. I am saying that the feeling that there are times that our courts have missed the opportunity to provide judicial leadership, which leadership would have helped in advancing constitutional justice or protecting fundamental human rights. Would you agree with me that we've had instances like that?
I disagree.
Okay. My lord, much as I appreciate your answer, is it your case also that in all situations the Supreme Court has scored 100% in providing 100% judicial leadership?
I will not say that it's 100% because it's a human institution. Because the judges have the right to go right, they also have the right to err. That is why Article 129.3 even provides that when a exigency comes or when there are situations that the Supreme Court will have to depart from its previous decision, they have the right to do so. They will not come out to say that they were mistaken anyway. But in doing so, they will require that there are exceptional circumstances for them to depart from their previous decisions. And then two, it must also be said that the exigencies of the time demand that they depart from their previous decisions. So I will say that being human institution, they are prone also to make mistakes. They are human beings. I mean, and there's no judge under the sun whose decision has not one way or the other not to be overturned. We are human beings. It's only God who is perfect.
Therefore, we've had instances of missed opportunities in judicial leadership. Now, my Lord, let me bring you back to this case you decided at the High Court. And if you can immediately recall, I'll refresh your memory on that.
Which one is that?
Yeah, I'm yet to say. In the matter of Ninoy Odonko versus the Iyoko, I can give you the brief facts of the case, just to recollect, for your recollection. If you remember, we would proceed. But if you...
It's a long time ago.
Sure, that's what I'm saying. I understand. My Lord, in the Ninoy Odonko case, Iyoko had frozen Ninoy's account without notice to him. The man had traveled out of the jurisdiction at the time his account was frozen. He came back into Ghana after some 5 years and made an application before you. Iyoko at the time had already expended the money which was in their exhibit accounts. Your ruling was to the effect that the time for him to apply was far gone, so time back, procedurally, you could not apply for the defreezing at the time he was. However, the argument that he was not in the jurisdiction, and in fact, when the matter went on appeal to the Court of Appeal, your position was sustained. A certiorari was also filed, and relying on the Supreme Court's earlier decision, in a matter I will remember very shortly, he was again denied because applying for certiorari, per the rules of court, you need to do so in 90 days. So this gentleman lost every opportunity at all levels because of the time factor. He was not in the jurisdiction, his money is gone, and his fundamental human rights had been infringed upon. His right to have access to his own cash in his account had been taken away from him without trial. My Lord, my position is that the approach in interpretation was rather unfortunately very strict in this situation of Ninoy Odonko, and I consider it as a missed opportunity for the judiciary to have exercised its judicial leadership to protect fundamental rights, because on the fact it was all obvious the man has not been tried, he was not even on notice, but he's been affected by time because he could not apply. Equity would not be for his benefit in that instance. What, my Lord, in the present circumstance, would you advise the interpretation approach should be, with this in mind?
In the first place, let me say that I'm very happy that my decision was affirmed. And when we went to the Supreme Court too, you were overthrown. But coming back to your question, you see, judges, I mean, it's right that we do justice according to law. We don't do justice according to emotions. The court that you came to for it was not a what do you call it, human rights court. You were not espousing human rights issues. Okay, you were talking.
But the equity will look at substance, not form.
Oh, but the equity follows the law. Equity follows the law. So if the law says that within 1 year, and we started the Financial Crimes Court, I together with this judge who is no more with us, we started, and that time the Eco law had just been passed, so we were involved in it. And I quite remember that there is a provision in, if it has been changed, I do not know because I left the court very, a long time ago. Under that law, if your account has been frozen and the ECO people do not prosecute you within 1 year, you have the right to come to court to challenge it and have your account defrozen. You see, I'm not sure about whether your client has then traveled out of jurisdiction, and if it did, you wasn't served with notice. I'm not sure about that. But what I'm saying is that once the law provided the time frame within which to come to court, and you were outside the court, look, and it's 1 year. If you stay abroad for 5 years and you come to court, how will equity help you?
Okay, my lord.
Honorable Leader, before you come in, let me suggest that if a question is posed to the nominee and the nominee is answering the question, we should allow him to finish answering the question before we pose another question.
My lord, the case I wanted to cite to support the earlier point I was making was the NCS versus Intelstat case. Have you come across that case? It was a 3-2 decision.
NCA what?
NCS versus Intelstat. So it's the 2012 Supreme Court of Ghana Law Report. NCS versus Intelstat. Intelstat. NCS versus Intelstat.
Yes, what happened in that?
My lord, it was a matter on appeal that went to the Supreme Court through a certiorari application. And the application was mounted after the 90-day window provided. And this was a case that my lord Bedegbe of blessed memory departed from his good brother Atuguba. It was a 3-2. He went with my lady who is now with the Council of State, I forgot her name, Akoto Banfo, my lady Akoto Banfo. It was a 3-2. My lord, in view of your argument that equity follows the law, and the fact that the courts in this instance apply the limitation rule strictly, that yes, the person did not was not in the country, but the fact that you were not in the country and the fact that Iyoko did not serve you notice will not endure to your benefit. The law says within 1 year apply. Now, if you read the Intelstat case very well, you realize that my lord Atuguba was making an argument to the effect that the court will not sit idly by and watch statutory provisions being breached. Now, with this on mind, Iyoko has breached the law. The affected party did not apply on time. You think that for this, his fundamental human rights should still be denying him because he was quote unquote indolent at Equity, and that the law says if you don't do it in a year, you are denied.
Let me repeat that I'm not too certain as whether the applicant in that case was served with a freezing order or not.
My lord, for record, he was never served. I mean, I say so on authority, and I can furnish you with your own ruling later.
I just provided some guide as the chairman of the committee that when a question is asked, let's allow my lord to answer the question, then we can interject. I believe that is the way we're supposed to go.
Okay, so maybe at a later stage, let me have the benefit of that judgment we are talking about. But my position is that you didn't go to Human Rights Court for enforcement of your human rights. Because if you went to Human Rights Court, the perimeters are different from the ordinary courts, like the Financial Crimes Court. They are quite different. And even the term limits, I think they are also different. So far as you didn't come within the rule, and equity will never come to your aid. Thank you.
It's okay. My lord, let's deal with another issue that has to do with charting a judicial path for the future of our democracy. Because for me, I think we, the political activists, for many years, will rely on our courts to keep this democracy alive. And I say so with a lot of passion in me. Without you, the courts, particularly the Supreme Court, this country's democracy will not survive. Now, with that in mind, what role do you think the Supreme Court should play in shaping Ghana's constitutional destiny in the next 2 decades? And how would you define your own judicial posture if presented with choice between restraint